The most anticipated rundown judgment in the SEC v. Swell case is probably going to be the one on the fourth positive protection, otherwise called the fair notice defense. The gatherings are coordinated to meet and give with regards to an instructions plan for rundown judgment movements. The gatherings will present a joint proposed plan for the court's endorsement no later than multi-week after the SEC's accommodation, Magistrate Sarah Netburn requested. The previously mentioned SEC's accommodation alludes to the offended party's solicitation to illuminate the court regarding its situation on whether any extra disclosure is required. The movement should be submitted in no less than 7 days of the documenting of the individual defendant's forthcoming response, which is expected April 8, 2022. This puts the SEC's situation on extra disclosure to be recorded as late as April 15, 2022, and the joint proposed scheduling order to be documented on April 22, 2022. A ongoing movement by the SEC unveiled that Ripple proposed an outline judgment plan with opening briefs and related fillings due in mid-May. Obviously, the SEC needs to plan the rundown judgment sometime in the future. The SEC accepts that such a preparation plan is untimely, considering that the individual defendants presently can't seem to answer the objection and argue certifiable protections, and deferentially demands that the court direct the gatherings to meet and give with respect to a rundown judgment plan once the SEC has educated the court concerning its situation on the requirement for extra disclosure. The most anticipated rundown judgment in the SEC v. Swell case is probably going to be the one on the fourth positive protection, otherwise called the fair notice defense. The SEC neglected to strike that guard in a significant win for Ripple and individual litigants, who likewise saw the court expressing its terms to ultimately agree with Ripple on fair notification. In a past court request, Judge Annalisa Torres called attention to what basic elements might make an appearance a future synopsis judgment on the fair notice protection, in the event that XRP was or not sold as a venture and in the event that Ripple has or no relationship with by far most of XRP holders. Swell denies the two cases and, as per the court, it can have a significant effect with regards to fair notification. If valid, would bring up legitimate issues concerning whether Ripple had fair notification that the expression, venture contract, covered its circulation of XRP, and the court might have to consider these inquiries all the more profoundly, said the court.